How much time?
2 weeks.
2 weeks.
Yes. Right?
Yes.
Right, please, Obama.
Please, madam.
Let me just itemize in point.
How much time you are waiting to do?
So I'll try and do it within 20 minutes, half an hour, because there is some urgent. Yes, I can't do justice less than 20 minutes. I'll be less than your lordship 25. Can give us just around 6 fellows. Also consider having the spillover Monday, Friday combination. We've done mostly today, I think. We've done.
No, you, I think you
It's a narrow issue.
we'll give you 15 minutes and 15 minutes to Mr. Jetwalan.
As long as your lordship restricts us both,
Yes.
okay. Very well.
We are all three of us have read the matter, so
Yes.
Be precise,
Enough.
short to the
be
point.
precise.
Precise, short to the point, and then tell us.
Your lordship knows I've been accused of pointillism.
That's right.
So I
We also-
shall try to be that. Now, Mills, very briefly. I've got 1, 4, 7, 8 heads. I'll just give you the pages. Mills, the first is, this is a Mills.
Where is that one page?
This time, what we have done is, we have drafted the synopsis like a written submission. Like a written submission, write it or rush it top of the file. But I will shorten that also, just keep it
No,
open.
doesn't matter. Keep it.
That is the short form.
We'll keep it. You can show us.
So, well, my first head, I'll make these 10 heads, well, one by one. My first option, note it down, will be easier with the pages.
You put it as first thing. As
Same.
Okay.
Well, it's the first head is that your lordship should not have any
Purpose group.
is that, and I give your lordship ABCD is there, but I'm not following the notes strictly. I'm making it shorter by your lordship. Nobody perhaps will help. It's the first time, Mills, that an admittedly, I use the word admittedly, amorphous group of 13 crore people have held themselves and have been accepted to a suing class as a defamed class. Now, Mills, the fact that this is amorphous, the fact that they are non-homogeneous, and the fact that the communities, the castes, and the groups with the appellation MODI are totally different is admitted. Note those pages, one by one. The best is 326. These little bit you also have to see. 326. We also the limited volume 1. It's a very strange conviction. All this will be ultimately decided in the conviction. I'm just saying a very strong case, which is why a lordship should suspend it. Stay. I mean, I'm not arguing the conviction of a lordship.
Today you are not
arguing the conviction.
You have to make out an exceptional case.
That's right.
For normally, stay of sentence has to be normally it has to follow. For a stay of conviction, you have to make out something more than.
That's right. So I'm exactly. So when I say these things, please don't think that I'm arguing against the conviction merits. But I have to show that there's a remarkably good case for conviction merits, which is why the lordship should stay the conviction, because the consequences are 2 years apart, 6 years, 8 years total. Disqualification for the leader of a political party in the world's largest democracy, whether this is proportional, etc. That's the overall picture. Now, kindly see. 326, right at the bottom. It is not true that Modi is not my surname from birth. Witness willingly states that his surname was Bhutwala. Right at the bottom of my lord yes.
This has also come in some other documents.
Yes, it's come for 3 places. Therefore, I'm giving you the best place.
I think I have marked it somewhere else.
I'll give that.
You are given the
yes
evidence separately, I think.
Yeah, my lord is right.
Yeah.
That's absolutely right.
I think
3, page 19 at 21. What my lord is Gawai mentioning
Volume
is
3.
volume 3, 19 at 21. That's the evidence. Additional. Volume 3 means additional document.
Okay, that's marked. Therefore, I should.
Mark it. So keep that document. Additional volume. Additional document. It may not be called volume 3, just additional document. 37815. I will give it to all my lords. It is not true. I hope it's the same parallel. I'm reading 326 if my lord will also get that.
Page 29 in that.
Yeah, yes, correct. Please follow it. It's the same thing. It is not true that Modi is not my surname from my birth. Witness willingly states that his surname was Bhutwala. It is true that my surname is Bhutwala, written in certificate produced exhibit 27 and 28, and my caste is Hindu Mod Khanchi. My caste is not written as Modi and Mod Vanik in the aforesaid document. It is true that my surname Mod Khanchi is not written in my complaint. It is true that my community is written as Mod Vanik community in my complaint. Mod Khanchi is not written. It is true that any documentary evidence is not produced. It is true that no documentary evidence is produced to support the fact that Mod Khanchi and Mod Vanik are the same. I changed my surname from Bhutwala to Mod in the year 1988. It is true that I obtained.
But that's a mistake. Just so it's Modi, not Mod.
That's whatever.
It's Modi.
I have not produced documentary evidence of 22 to 30 along with the complaint. I am producing today for the first time. It is true that I have stated in my chief that no written evidence has been produced. Now, this is important for us to show that Rathod, Gupta, Teli, Modi, Khanchi, Chaudhary, Das, Chetiyar, Shahu are castes or subcastes of units of Modi community. It is true that there is no documentary evidence to show that Modi Samaj is known as Mod Vanik in Gujarat. It is true that persons having various surnames belong to the Modi Vanik Samaj. It is true that I have no documentary evidence to show that persons surname are belonging to the Modi community. I'll stop here. I'm finishing one point in vertical, but then I'll go to the next one. Not finish this point. This is the same or similar. In the trial court, it is noted at page 259 to 60. Don't go to just don't the page. It is also, as my lord rightly noted, the evidence in page 29. Now, brothers, the persons who are named in one sentence in a 3-page speech in Karnataka have admittedly not sued. Admittedly. We are not concerned about them. They are not complainants. These persons.
That has also been admitted in the evidence of this witness as well as the evidence of Ganesh Bhai.
Yes. I'm very grateful you have read the evidence also. I'm very grateful. It saves time. Note one thing, brothers. It would be extraordinary that everybody who is aggrieved in 13 crores, the figure 13 crores given by them, the complainant side, happens in this very small community of 13 crores to be a BJP office holder. So, point one, the person's name are not suing. Point two, of this very small community, inverted comma small, of 13 crores, one claim in Gujarat, which is the current one in Ranchi, one in Patna, across the country, but all of them happen to be only BJP office bearers or BJP Karyakartas. Now, let's kindly go further. In Subramaniam, I'm finishing this one point. In Subramaniam Swami, at para 177, this is directly dealt with, that you can't have defamation at all. That's plus 2016, 7 SCC, 221.
Subramaniam Swami.
2016, volume 7 SCC 221. It's in the judgment volume we've given.
No, that is also reproduced by the learned single judge of the Gujarat High Court.
The passage your lordship will see from. They say that you must be an identity. Just see the passage from the original. Can you give the case law volume, please? Give the case law volume.
We've seen that.
Well, that little hitting if I just take a minute.
No, I learned brother had an advantage of arguing the matter. We did not have that advantage.
What is worse, I'll tell lordships a secret for us. I successfully argued against Mr. Subramaniam Swami in that matter. Mr. Subramaniam Swami said criminal defamation is unconstitutional under Article 21 and 19(1)(b). 19(1)(a). I said no, individual cases can vary, but criminal defamation is not unconstitutional. I'm letting you lordship into the secret.
I see.
Justice Mishra's headed bench accepted my argument. My learned friend was for the government, because I was for the people who were complaining. But for us, it's only on constitutionality, not on the individual case. Yes.
The fourth is a case law.
Or we can get
At
all.
this point, Dr. Singhi.
But those words are evocative. Those words are evocative. I need the case law volume 4, madam. It's faster and quicker.
Case law. Spiral bound.
Spiral bound, please give it.
In this.
This is what takes time sometimes. While it is being got, it relies. Very well, I'll show you. At page 336 of the SCC volume, 2016 7 SCC 221, relevant at 336. The relevant para is 177. 176, sorry, 176.
Case.
My lord relies on Mehra and more particularly on Narsimhan, but just read 176. While this is the first point, while we decide to call, if we would constitute a clear cast,
No, 176.
176 para number, page is 336.
It begins with more than 5 decades back.
That's correct. Sahib Mehra, while being called upon to decide whether PP would constitute a class or come within definition of collection of persons referred to in exhibit explanation 2 to 499, held that a collection of persons must be identifiable in the sense that one could with certainty say that this group of particular, mark the words, one could with certainty say that this group of particular people has been defined as distinguished from the rest of the community. The court in the facts held that prosecuting staff of Aligarh, or as a matter of fact, the prosecuting staff in UP, was certainly such an identifiable group of collective persons, and there was nothing indefinite about them. Thus, the authority emphasized on the concept of identifiability and definitiveness. In Narsiman, the court dealt with the applicability of the explanations regarding association or collection of persons and ruled that a collection of persons must be, this only these words, must be an identifiable body to say it's possible to say with definite in their group of particular persons as distinct, which I won't read the rest. Your Lordship has evidence saying that in that 13 crore, there is no uniformity, no homogeneity, no identifiability, no boundary line. That's point number one. Point number two, Malas, is that he himself says I was Bhutwala, and he himself says I adopted the word Modi later on. Now, Malas, the second point. Let me make the point first and then I'll also speak. Under your Lordship's 499 IPC read with explanation 4, intention to harm or knowing or having reason to believe to harm is in the statute itself. And the evidence says, I have no idea of intention of Mr. Rahul Gandhi. These 2 points only make my second point. First, see the section. Can you take out now?
Section 499.
499 with the explanation. Open it. Your Lordships had an explanation added, Malas, in terms of explanation 4 by the statute itself, which is, Malas, no imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others lowers the moral or intellectual character or lowers the character of that person in respect or lowers the credit of that person or causes it to be believed that the body of person is in a loathsome state or in a state generally considered as disgraceful. Now, Malas, just note, this is not so important except to make the point of the statute. The point is complete by seeing volume 1, 268, which is exhibit 60, the evidence of P.W. Rathod, relevant at 270. 268, relevant at 270.
Volume 2.
Volume 1.
Page.
268 it starts, relevant at 270. This is the trial court itself.
4 is actually not an intention clause. Explanation 4 is not an intention.
Well, it's
Anyway, it shows what he says.
Yes.
At 270.
no, but I'm sorry, I should have read. No, actually, I said 499 read with 4. The word intention is it 499. I should have read that. The opening itself, third line. Any person intending to harm or knowing or having reason to believe. I said that I didn't read it. My mistake. Now let's turn from 269 and 272. I'm sorry, Justice Dawai will see. Intending to harm or knowing or having reason to believe that such imputation will harm. That has to be the link with 4. What harm? Harm to reputation. Now let us come to 269. It is not for this point, but I am reading 270, so I might as well read 269 for 30 seconds. Please go to 269. It is true that any of the 4 persons, middlemen.
269 you are reading? It
This
is
is
true,
also
yes. It is true that any of the
trial court. It is true that any of the 4 persons, namely so and so, with whom Rahul Gandhi had compared Shri Modi, do not belong to our caste. Now come to 270, which is what I wanted to read. On intention. Sorry, just this. 270. 70. This is what I wanted to read. It is true, third line. It is true that Rahul Gandhi meant to state in his speech that so and so are thieves of this country. Now they were sued. It is true that this speech does not contain anything about our surname. The witness has further stated that he is not aware of the intention of Sri Rahul Gandhi after referring to the word Modi by the word Chor.
Who is this Rathod?
Rahul is a prosecution witness.
But he's from that mode,
Complainant.
one of the more Dalit community people.
On defamation, only 2 witnesses.
No. One of the main witnesses is that Ganesh Bhai. Ganesh Bhai.
Ganesh Bhai Yaji.
Yaji.
Not that is a witness, eyewitness subsequently introduced.
That I'll deal with.
He doesn't speak about defamation, doesn't comment on this. He says, I heard the speech.
My lord,
Introduced after 1 year and 9 months. The only 2 witnesses,
Complainant and Rathod.
are complainant and this man.
Now, brothers, that's my point number 2. So the necessary ingredient, and these will be all very small. Now, the third is I submit fatal.
You give us pointers.
Third, fatal, brothers, I submit fatal. Because this is a little important, brothers, so I don't want to miss out. Brothers, the learned judge gives a The learned judge gives an extraordinary finding with deepest respect, brothers, in para 44. He treats this as a serious and a moral turpitude offense. Note these 5 factors, brothers. Not a single judgment is cited, not a single material to show moral turpitude. Note 1.
Oh, even this learned trial judge observes about moral turpitude.
No, the High Court
High Court observes about moral turpitude.
So this is an introduction, brothers, which is nobody's case. It has not been. Some material has to be there, some case law has to be there. But now just see something startling under this point. So lot of people call it the third point of moral turpitude. 1. Well, I have yet to see that a non-cognizable, deepest respect and humility I say, so it is admittedly non-cognizable, bailable, admittedly bailable, and compoundable, admittedly compoundable. And incompoundable, as the Lordship knows the criminal law, there are 2 parts. One is compoundable between the parties, one is by the state. This is the first part.
321 and 2.
An offense with these 3 characteristics, not against society, not kidnapping, rape, or murder, maximum sentence, which I don't know if any case has been given. There may be, I may be factually wrong. No case I know of 2 years maximum becomes an offense of moral turpitude. If your lordship were to have this definition of moral turpitude, and that is influence the judge. Para 44. So, this is, and for this, a person must be silenced for 8 years. It's not 2 years. It's 8 years. In democracy, we have dissent. In democracy, we have disagreement. I agree, that somebody decide the conviction. It should be what I call in Hindi the correct word, Shaleen language. I understand. I don't think this man in any way intended to make it that personal. He was saying a different sentence altogether. I'll come to the meaning in a minute. That is it may. On moral turpitude, along with that, the learned judge treats it as a heinous and a serious. It is added. See, if a lordship thinks it's heinous and serious, then conviction should, disqualification should continue. No rape, no murder, nothing. And no case is given for this. I don't know of any case where all 3 intersect. Compoundable, bailable, it's a non-cognizable. 2 years. My learned friend who is an expert on criminal law conducted the first appellate court trial. Says that 22 offences alone have simple imprisonment in the entire IPC.
No, but the learned trial judge.
22.
No, also talks about your criminal antecedents.
No, that's the next point. That's the next point. So, I am a criminal. That's the next point. I am a criminal. Why am I a criminal? Because A, I apologize to your lordships in court 1 in a contempt matter. B, there is no conviction about none. Under B, there is no conviction.
Yes.
Now, I'm a criminal after conviction, I hope. Now, there is no conviction despite just a chart for 30 seconds at the end of the volume. 139. Well, the chart is full of cases, ironically always filed by BJP Karyakartas, but no convictions. Well, these are prejudices, these are
It
animated.
is also the moral turpitude argument.
I beg-
You have covered the.
Yes, so this is the fourth.
Amorphous group. Number 2, you said there is no intention.
Correct.
Number 3, you said
Moral
no
turpitude.
moral turpitude. Then what else?
And fourth is criminal antecedent, which is coming later, but my lord observed. So I said I'll deal with it here. Criminal antecedents, hardened criminal? No. Conviction in any case? No. In a contempt, your lordship has convicted me of contempt. I appear in that matter. I apologize. I mean, there are political overtones to it. This happened, that happened. We don't go into it. So I'm a criminal antecedent. Well, there has to be some mutual respect in politics. Well. It's all right. You don't agree with me. I'm not a criminal. Well. Then, let's see the chart for 30 seconds, 139. It will be a visual.
Next to P21, 130.
Volume 1.
Volume 3, additional.
Additional. Just keep those things.
170.
What the volume will also give just now. Additional volume you gave to my lord, same volume.
The 139.
139. Now, Millet, I will not read their association with the organizations associated with the ruling party that is given in the chart. Well, it is of course very interesting. As I said, out of 13 crore people, apparently everybody agreed to be a BJP office bearer or a Karyakarta, out of 13 crores. But that apart, this is a different point. These are a list of 13 odd cases, which are all no conviction cases. How am I criminal antecedents? That's point number 4. Point number 5. The moral turpitude, note one side point that there is silence judgment as to how what moral turpitude, which judgment moral turpitude. Nothing, it's just a conclusion. Number 5, Manas. This shows Manas how the mind is working and how the errors are made. A new offense, not alleged by the complainant, not arising in the proceeding, is found against me in para 43. And the offense found against me, I repeat, found against me, doesn't exist in this case. Don't go, just note para 43 and read this one. You need not even read it. The offense given as a finding in para 43 is 171G of the IPC. Now note 4 points. Lordship will be, with great respect, I say, these are serious matters for the person who suffers this disqualification. It may not be very serious if you write it casually. How can this be given, and least of all by the High Court? And the learned High Court judge reserved orders for 66 days after I finished argument. 66 days. This order was reserved, which your lordship has got impugned here, for 66 days. I finished arguing in May. Judgment came in July. 171G, note 4 point. Don't read the paragraph. A. 171G applies between candidates. B. The word candidate is defined in 171, capital A, small a.
Yeah, we are not on that because, we are on the question as to whether the conviction as recorded by the High Court is required to be clear or not.
But the High Court sustains it on this ground. It's a full finding. I'm only pointing it out.
For our purposes.
The less said, the better about the judgment of the High Court.
Very well.
And particularly the judgments coming from the Gujarat High Court.
And the words are tarnishing character of candidates. So in an election campaign, if I tarnish his character, then 171G will apply. This is not an election campaign where I tarnish his character. And it is not a complainant's case. That's number 5. Your lordship can see that, pardon me, I'm going a little fast, but I have to keep your lordship discipline. 5. 6 is that the consequences of this are the following. Please note that. A new election will be notified. In a lighter vein, I may say, perhaps only because the constituency in the state is Kerala, that it has not already been notified. Perhaps politically the chances of victory there are seemingly bleak. But
we don't
anyway,
don't use it as a political platform. We are only concerned about the legal issues.
I withdraw my remarks.
You and Mr. Jetmal reserve it for Rajya Sabha.
Yes. Now, my lords,
I'm not concerned with that at all.
that is one. Second,
When it functions, when it.
second, I have, my lords, lost 2 terms already. This term I'm not counting. This is ending on, my lords, 1 week, etc.
Lost 2 terms.
Session.
Lost 2 sessions.
Not 2 terms, sessions. 2 sessions.
2 sessions.
Number 3, this, my lords, if the Supreme Court says no, I lose virtually, effectively, my lords, the entire term unless I'm acquitted. I don't know when that happens, but the entire term goes. This is the last call. Number 4. Number 5 is very important under this head. It's all under this head. Well, it's Mr. Jethalani, I don't mean him, I mean his client. He cannot be, Malas, too vigorous in saying that while the conviction is pending for acquittal or affirmation.
Anyway, you don't advise him as to what he has to argue. It is for him to what to argue and what not.
No, I'm saying in a matter of principle, Malas, he cannot have that interest, Malas, unless it is vindictive. It is, Malas, in that sense person. Then, Malas, please also note this point about, Malas, evidence is very interesting. Just give me a minute, please.
Mr. Sangeet,
Yes.
2 more minutes.
Very good. Whereas, two more things very quickly. Whereas 8(4), which your lordship declared ultra vires, at an auto stay. That is, whereas you file an appeal on conviction, it stays automatically. Lordship declared ultra vires, which is why we have this situation today. Now, it's very interesting and forgotten.
Who is responsible for that? Lighter vein, sorry.
Now, yes, that question sometimes comes in the unamended PMLA cases I argue also. Unamended. Of course, a lot of amendments are after 2014. Major one. Anyway, I have not answered that for the time. Now, after 8(4), just note one thing. In Lok Prahari, a very well-known judgment of the lordships, the specific argument in para 7 was that even now there is no 8(4). But even if the court gives a stay, the disqualification should continue. That's the argument noted by lordships. And it is rejected in 16 because of the ground that he is remediless. Pending conviction being decided. That's the spirit of it. I'm just pointing that out. One other thing, Malas, evidence is very interesting and very important. Please note, this is the case. This I'm saying only to show how the conviction can't be sustained. Apart from this, I'm not arguing the merit, but I have to say this to lordships. Malas, there is no evidence at all till now. The trial is over, conviction has happened of the event. Note how. A. Its complaint starts with the complainant saying, I got a WhatsApp saying that Mr. Gandhi said so and so in Kolar. And it has a WhatsApp with a newspaper cutting. Some bird dropped it into my WhatsApp system. That's the case. He does not say who gave it, how it came. Thereafter, Malas, he goes to the Election Commission and he records statements, my statements, etc. all recorded 313. In all of that, the actual event, the speech, is not proved in any manner as per 65 B(4) of the Evidence Act, which your lordship is held to be mandatory. Please take it because lordship is not hearing the conviction appeal.
We have gone through that.
Yes.
Now,
therefore,
the High Court says that issue cannot be considered at this stage.
Now, there is therefore no evidence. Once your lordship excludes this evidence, no, one more sentence. In between, the complainant goes to the High Court, and gets a stay of his own trial saying, I want to get this evidence, which I am saying is not there. He realizes that he has not got the evidence, so he goes to the High Court, gets a stay of his trial, and say, I want to get this evidence through 65B certificate or whatever. 1 year later, miraculously comes and says, quote unquote, I have now sufficient evidence. Please remove the stay which I had myself got and send it back to the trial. Between this time and this time, not a comma is added. 1 year later, 1 month later, the conviction comes. He has propitiously gone to his own stay, got it vacated, comes back 1 month later, the conviction comes. Now note this one. This, if your lordship excludes, No evidence of the speech. None. Then the only person left is this miraculous Yaji, Ganesh Yaji.
Ganesh bhai.
Ganesh Yaji's name is. Now, note this about it. Yaji is not mentioned in the complaint. Yaji comes with no complaint himself. Yaji is not born for 1 year and 9 months.
Anyway,
For 19 months. I'm sorry, 21 months. He is an afterthought. He's a BJP Karyakarta or associate who is invented after 2 years.
no, not Karyakarta, he's an important functionary.
Function, he's the office bearer.
Yeah, he says that he is looking after all those public
Cultural
meetings.
advisor to be precise. The higher the post, they say it's a Karyakarta. That's the. Now, may I say, he comes 21 months later as a person interested clearly to validate what is not
Anyway,
validated.
yes, Mr. Jethalan.
Mr. Jafnan.
Hello, first of all,
30 seconds more. Just
No.
very good. Lord, should may ask me if there's something I left out in the
If you want, then we'll ask him.
Yes.
now, first of all, the defamatory part of the speech, the most vital part, my learned friend has not referred to. Kindly see what the defamation is. At page 5 of my reply, your Lordship will find it.
Why reply? You go through, take us through the judgment of the trial court or the high court.
No, because I'll tell your Lordship that the impugned portion of his speech is in the election commission tape, which is proved. That is why we did it. Because there's a plethora of evidence in this case. First of all, there's oral evidence of the complainant, but admittedly he wasn't present. But he saw it on YouTube, downloaded it on a pen drive, and tendered it in court. First. Second, there's a gentleman called Yaji who made the application to the official record, where the official record of the speech is by law kept, which is in the office of the election commissioner. He made this application, got exhibit 26, which are the CDs of the speech. Yaji, who was at the meeting, and that is not denied that he was present at the meeting, Yaji. He was then shown exhibit 26, the election commission report, record of this actual speech, CDs, and he said, this is exactly the content of the speech that I heard when I went.
But he also states in the evidence that there are certain sentences missing in that speech.
No, I don't know what it is. No, that is what has happened.
Adverse is in cross-examination.
No, my lord, I'll explain that. My lord, that's a bit of a confusion with these explanations. The entire speech of Mr. Rahul Gandhi spread over 50 minutes.
50 minutes, including translation in Kannada.
Yes, but yeah, that's the act.
That's what Ganesh Bhai says in his evidence.
Yes. So what has happened is these portions are not. It's the 3 CDs that were produced were not CDs. Each of the entire speech. The entire speech, including, as your Lordship said, the translation by the Kannada interpreter, covered 3. So the impugned portion was in CD number 2, and that's marked. The impugned portion, the defamation part, out of the 3 CDs is CD number 2. Please note that. But it's all very well in one sweep to say it's not in certain portion, but the impugned portion is only in one, which is number 2 out of the 3 CDs.
In CD number 2.
CD number 2. Now, that's the authentic version. In fact, the CDs produced exhibit 26, undenied that the man who recorded the speech under the directions of the election commission to see that the model code of conduct was complied with was PW8. He was the supervisor of the videography that took place on that day, on the date of the speech, that is 13th April. He is examined as PW number 8. Yes. So there are 2 vital witnesses apart from that, so that we make the speech part completely unimpeachable. The videographer, under election commission orders, supervised the videography. The photographer, the man who actually had the camera, they are 7 and 8 respectively. Both of them say that the CDs which are now produced in court, which came from the election commission office, which is a public record and therefore entitled to the highest presumption of truth, contents included, they corroborate that public record and say that when we went there, we are the persons who videographed the speech, and we are the persons who confirm now in court that these exhibits 26 are exactly what was said. So Yaji says three people who are at the speech. Yaji,
This is more in the context of the existence of events. I don't think he has so much part. Then move on.
so
So much on it.
so the contents of the speech are established.
No, that will be the merits of the matter to be considered at an appellate stage.
No, I'm just going point by
Because
point.
Dr. Singh, you raised that point, you are saying so far the speech is concerned, it is
It is-
unimpeachable.
And if your lordship just see the suggestion put, if your lordship just see the suggestion put, this is the suggestion in the evidence to PW1. It is true that my surname Modi, this is their suggestion, is appearing in the defamatory remarks made by the accused in the speech. But my individual name, Purnesh Modi, is not appearing. So I have defamed his own words, and I've looked at the Gujarati translation. His own words are that all people with the consequences, all people with the surname Modi, including the complainant, have been defamed by the accused, but not you, Purnesh Modi. Now, I come to identifiable class. First, let me just point out what is the defamatory statement at page 3. And your lordship's get 3 is in every reproduction. Well, this was widely reproduced all over the country, the speech, and it had never been denied. But that's just only an addition because the CDs from the Election Commission approved by the person who actually took the CDs. Now, at page 3 of my reply, paragraph 4, this is what is said. अच्छा, एक छोटा सा सवाल, इन सब के नाम, इन सब चोरों के नाम मोदी 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 कैसे हैं? नीरव मोदी, ललित मोदी, नरेंद्र मोदी, and look what he goes on to say, और अगर थोड़ा ढूंढोगे तो और बहुत सारे मोदी निकल आएंगे. His intention was, forget reason to believe, his intention was to defame every person with the surname Modi just because their surname happened to match that of the Prime Minister. This is ex facie malice aforethought. You have defamed an entire community, an entire identifiable class of people bearing the surname Modi because it bore the surname of the Prime Minister. The caste part is the secondary part. There are 13 crore members of the Mod Vanik. So there have been two defamations in this case, as far as the complainant is concerned. The first defamation is, I bear the surname Modi, and that went on. And what does he say in his 313 speech? The gentleman says in his 313 speech, I cannot remember my speech. In his 313 statement, he said, I do not remember my speech. So, he corroborates the content of the speech.
Many of the politicians, or how many of the politicians would remember what they speak? At times, they have to address 10 meetings, 15 meetings in a day.
But
one may not even recollect what he has spoken in an earlier meeting.
when you are speaking, when you are accused person in a case, prior to that, you should read the allegation made against you. Then you say that no, I don't make, I haven't made this. What is attributed to me is false. It is true. If he wasn't an accused in a criminal case, he may not remember. But now you're facing a trial and there's a welter of evidence against you. Witnesses, oral evidence, and election commission witnesses, public servants. How is that impeachable? Now, my lord, he says 499(2). 499(2) is explicit. There are many judgments. On that indirect reference that corruption was rampant amongst public servants who were discharging the duty of administration of justice in Aligarh. This court has held that every public servant who was holding that duty of discharging the administration of justice, every public servant in that state, not just Aligarh city, but entire UP, because it was ambiguous in that case, 1965 Supreme Court. has a cause of action for defamation. It's an identifiable class. So also, everybody with the surname Modi is an identifiable class and has a right to sue under 400. He has locus. It's a manifestly identifiable.
We are not on the merits of the matter. We are today.
This was. I'm dealing with the submissions.
Yes.
I'm dealing with the submissions. I have to do it. Where, my lord, your lordships are satisfied, one way or the other, I won't go into it. Third, I'm only going point by point with his points for stay of conviction. 8.3, which is
Of the representative people.
of the representation of people, nowhere mentions the word moral turpitude. It doesn't have to be. It says offences punishable up to 2 years. 2 years or more. Where the legislature, I don't want to expand too much on this, but I've got a list.
Representation of people, I think. Yes. You go ahead, yes.
8.3,
Of Gandhi.
just of any sentence, and sentenced to imprisonment for not less than 2 years. Other than offence referred to in section 1 or subsection 2 shall be disqualified from the date of conviction and shall continue to be disqualified for a further period of 6 years since his release. Now, today we are on a very limited portion, aspect of the case.
You are referring to
8.3.
yes.
Now,
Yes.
now, your lordships in Lily Thomas's case advisedly struck down 4. Now 4 is making a backdoor entry through applications for stay. The whole idea on which 4, which gave breathing time and said that an appeal is pending. Please see what is 4.
Yes.
Notwithstanding anything contained in subsection 1, subsection 2, subsection 3, a disqualification under either subsection shall not, in the case of a person who on the date of the conviction is a member of parliament or the legislature of state, take effect until 3 months have elapsed from that date, or within that period an appeal or application for revision is brought in respect of the conviction or the sentence until that appeal or application is disposed of by the court. Now, this was done on a construction of Article 102 in the case of MPs and 109 in the case of MLAs. That the disqualification on the occurrence of the event is automatic and immediate. Number one, what has been taken away by this court in Lily Thomas is now being sought to be revived by an application for conviction. And of course, applications for conviction, or stay of conviction can be granted, but the law is too well settled. You must have a very, very obvious point which negates that conviction. There are a number of judgments.
Yes.
Again,
Well settled.
you can't appreciate evidence, etc. And this is, not one piece of evidence which he has stated. The ingredients are, was the statement made? Yes. Was it defamatory? Yes. Your sentence, you have a grievance about it. It has been stayed. Sentence has been suspended. Appeal is pending before the Sessions Court. There are 9 witnesses in this matter. What is your daring hurry? Unless you don't have a case on merits.
Whether one of the factors
Yes.
that a constituency which elects a person would go unrepresented in
My lord,
the
yes.
parliament, not a relevant factor.
My lord, it's a relevant factor. But then,
One of,
This issue has not.
and the learned trial judge
yes,
has granted maximum sentence of 2 years. The sentence is 2 years or fine
yes,
or both.
yes.
So why, when you grant a maximum sentence,
Absolutely.
you must give some reasoning as to why the maximum sentence is being imposed.
Yes. Now,
Not a whisper by the learned trial judge.
my lord, I'll tell your lordship. Your lordship may kindly see that order.
In
And
one,
that's,
in one paragraph,
yes.
he sentence that I am awarding him.
No, my lord, let us, so your lordship is right. Let us just see the order of sentence. If your lordship just read that. Page.
You must start with the first question also that is put to you by my.
Yes, yes,
That's very important so far as the present case.
yes.
You are not only affecting a right of a one individual,
Yes.
but right of an entire electorate of that particular constituency.
Yes, my lord. But my lord, that the
So while doing so, though the learned single judge has widely discussed that merely because one is a member of parliament and therefore he is not entitled to a special treatment and all that, but has he even touched another aspect of the matter?
no, that part he has. I mean, he's not talked about the constitution. I'll tell your lordships why. You your lordship just see the
He
order.
says that merely because one is a member of parliament, it can't be a ground for granting special concession.
Yes, yes. No, on the contrary, a higher standard is called for a member of.
That's what the learned he gives quite a lot of preaching as to what is expected of a member of a parliament, and this 125 pages reading makes a very interesting reading,
My lord,
and therefore I observed in the beginning itself
yes,
that some of the judgments coming from the learned Solicitor General State, who is just now on the screen,
yes.
make a very interesting reading.
But when he becomes the Solicitor General, he speaks for the whole country. But yes, it is his original state. Your lordship is right.
No, it's
But my lord,
his original state, you say.
Original state.
I still say that I belong to Amravati.
And I also belong to Gujarat, my lord.
Yes.
I proudly say
no,
that.
no, therefore he can defend those judgments.
And when it comes to further mini classification,
Yes.
when they say that I belong to Bombay, I say I belong to Nagpur.
And my lord, it's a Nagpur judgment of 1933 which
Yes.
puts this high onus. I have that judgment. 1933 said that no indulgence should be granted to any person holding a high public office. I'll point out the judgment, the 33 judgment. But let us first see what the judges say. Let us see what the sentencing judges say.
My lord, basically, my lord, since I am.
It's in
come
the
from
paper
that-
book.
only a minute,
It's at 455.
Mr. Jetmalan.
Yes,
my lord,
sir.
since that's my parent high court, my lord, I must
Yes.
point out, my lord. My lord, many a times, non-giving reasons, my lord, is criticized by the Honorable Supreme Court, and therefore, my lord, judges try to give elaborate reasons. But, my lord, any remarks, my lord, I'm just saying this with folded hands.
No, we are not making off the cuff remarks, but we are making remarks because I have personally come across two of such matters.
Yeah, I understand, my lord. Generally, my lord, they are crisp.
Generally, we are very slow. We
No, no,
definitely
my lord, therefore, my lord, it's
No, no,
little, your lordship knows, my lord, it's little, my lord, it acts as, my lord, kind of a demoralizing thing, my lord.
You know, it is demoralizing for the High Court, and therefore we are very slow in making.
Your
such
lordships
remarks.
are slow, my lord, therefore. But sometimes, my lord, when arguments are lengthy,
At
Mr.
least I am the last person to observe anything about unless it is so glaring.
Yes, my lord, Mr. Dr. Singhvi going there, arguing long for, my lord, I'll not go into the days or hours.
I don't know how long are we?
That is also, my lord,
Mr. Solicitor,
Wait.
let Mr. Jetmalan finish it.
They're eating
so
into my
the
time.
judge, therefore, my lord, elaborates his judgment, that's
1
all.
hour, Malas, and a rejoinder of 15 minutes.
Yes.
I don't think that's excessively long. And I wish I could do
It's just that.
Mr. Jetmalan.
No, I don't say so.
Let him complete.
I did say
a
so.
connection with Gujarat, who are
Mr. Chiva, please.
Let us focus on.
Only incidentally about Gujarat, but it's about.
No, Dr. Singhvi also has a connection with Gujarat. He cannot say no.
That's all right.
Yes, Mr. Jerman, continue.
He's only a pro forma party, by the way. Well. Your Lordship has given an entry to Mr. Tushar Mehta. He's a pro forma party.
Lord, I have counted 4 minutes of my time that was taken up by them. So, Your Lordship. No, just the order regarding punishment. On convicting the accused for
Page number.
sorry, 455 of the main SL.
445.
455. 450.
It's heard regarding punishment.
Yes, heard regarding punishment. On convicting the accused for aforesaid offence, on asking him regarding sentencing, he states, whatever lecture I gave, it was in the interest of the people. As part of my duty, I do not have any discrimination with anyone and I love the people of my country. But obviously not people with the surname Gujarat or Modi. This is his response.
It may be an incorrect translation.
No, we've gone.
This is English.
I have sat with my
The original judgment is Gujarati or English?
Gujarat. But my lord, I have sat with my instructing advocate and my lord made sure. And where there are some corrections, I will tell your lordship. The learned advocate for the accused has submitted that the accused did not have any intention to insult anyone. Due to the same, there is no pain or harm caused to the complainant. How can he say there's no harm caused to the complainant? There's a harm to my reputation. If you call me a chore and say all Modis are chores, further.
We are only saying what is the reasoning given by him
Yes.
imposing the maximum penalty.
I'm coming there. Further.
For sentencing, we know.
Yes.
Had he been given 1 year, 11 months, 29 days, he would not have suffered the disqualification.
Lordship is right. I'll just come to it. Further, prior to this, please, I'm just reading that whole, that order is all I read in toto, because taking one paragraph here may not serve the purpose. Due to the same, there is no pain or harm caused to the complainant. Further, prior to this offence, the accused had never been convicted for any offence. Now, this is wrong. Because the Supreme Court in Rafael's case, and that the incident happened only 3 days earlier, convicted him and gave him a punishment of admonition. He apologized belatedly. I'll just read the brief part of that order, but I'll come to, let me finish the whole order. Also, the accused does not seek mercy or clemency. Now, my lord, that is, my learned friend will tell your lordship in Gujarati what is the maafi. He said, I don't seek any forgiveness. The word used is maafi. Yes, sir. I don't seek any forgiveness, which means you do what you want. What extenuating circumstances have been pleaded by him, except that I have no previous conviction?
Yes.
Learned advocate, my lord, age is not a factor in his favor. Mental or physical health is not a factor in his favor.
Let us complete the reading.
Yes.
Because you can't substitute his order.
But I can tell your lordship what is not in
We
there.
have to read whatever there is in black and white here.
My lord, I can point out what is not in there.
So therefore, let us read it.
Learned advocate for the prosecution has submitted that it is very much necessary to consider the conduct of the accused. Further, in connection with the case of SLP number 46 of 18, before the Honorable Supreme Court also, the accused has sought for clemency in writing, and the Supreme Court had admonished him. Admonished him is he was convicted for contempt. It is an offence. The previous conviction. The Lordship sees the definition of offence. It is anything punishable by law. Further, present accused member of parliament, if he is imposed light punishment, it will set false example in society. Further, to consider conduct of the accused and to impose the maximum punishment and fine to him. It is also submitted to direct paying compensation to complainant in connection with this case upon considering submit the both parties. My lord, that the facts of the case and the disputed statement given by the accused, that although the accused was admonished by the Honorable Supreme Court, there is no change in his conduct. Now, my lord, let me just put that in perspective. Your lordship may just see that order of the Supreme Court. On 10th April 2013, he makes a public speech in which he says that the Prime Minister of this country was indicted by the Supreme Court in Rafale. The Supreme Court said Chaukidar Chor. Now, please see, my lord. It's a very short order. The lordships kindly turn to page volume 2 of my learned friend's paper book.
Yes.
In his judgment compilation. Volume 2.
Page?
Page 1006. It begins at page 988, for the relevant part, the contempt order on the contempt petition.
1006.
Yes, 1006.
Yes. Para?
Para 25, the title is there, contempt petition, number so and so, in 46 of 2019. The contempt petition emanates from an allegation against Mr. Rahul Gandhi, the then President of the Indian National Congress, on account of utterances made in the presence of several media persons on 10th April 2019 by him, alleging that the Supreme Court had held that Chaukidar Prime Minister is a thief. The Supreme Court was also attributed to having held in consonance with what his discourse was, i.e. that Prime Minister of India stole money from Air Force and gave it to Mr. Anil Ambani, and that the Supreme Court had admitted that Mr. Modi had indulged in corruption. It was stated that the Supreme Court had said that the Chaukidar is a thief. Now, this is all Supreme Court judgment. I am not. On notice being issued, reply affidavit dated 22nd April was filed, averring that the contents were made on the basis of a bona fide belief and general understanding of the order, even though the contender had not himself had the opportunity to see, read, or analyze the record at that stage. It was further averred that there had not been the slightest intention to insinuate anything regarding the Supreme Court proceedings in any manner, as the statement had been made by the contender in a rhetorical flourish in the heat of the moment, and that his statement had been used and misused by his political opponents to project that he had deliberately attributed the utterances to the Supreme Court. In that context, it was averred that nothing could be further from my mind. It is also clear that no court would ever do that, and hence the unfortunate references for which I express regret to the court order and to the political slogan in juxtaposition, the same breath in the heat of the political campaigning, ought not to be construed as suggesting that the court had given any finding or conclusion on that issue. The acceptance of such an affidavit was opposed by the petitioner, a BJP member of parliament, in the contempt petition. It was stated that instead of expression of any remorse or apology, attempt was made to justify the contemptuous statement as having been made in the heat of the moment. On arguments having taken place in this context and realizing the seriousness of the matter and the inadequacy of the affidavit, the learned counsel for the contender took liberty to file an additional affidavit. While they ordered dated 13th April, this court left the admissibility and acceptance of such an affidavit to be considered on the subsequent date. As an additional affidavit was filed on 8th May, stating that the contender held this court in the highest esteem and respect and never intended to interfere with the process of administration of justice, unconditional apology was tendered by him by stating that the attributions were entirely unintentional, non-willful, and inadvertent. Matter was once again addressed by the learned counsel. We have given our thoughtful consideration to the same. We must note that it is unfortunate that without verification or even perusing as to what is the order passed, the contender deemed it appropriate to make statements as if this court had given an imprimatur to his allegations against the Prime Minister, which was far from the truth. This was not one sentence or a one-off observation, but a repeated statement in different manners conveying the same. No doubt should have been far more careful. The matter was compounded by finding a 20-page affidavit, a large number of documents annexed, rather than simply accepting the mistake and giving an unconditional apology. What is it? We must note that it is unfortunate that without verification or even perusing as to what is the order passed, the condemner deemed it appropriate to make statements as if this court had given an imprimatur to the allegation against the Prime Minister, which was far from true. This was not one sentence or a one-off observation, but a repeated statement in different matters conveying the same. Not here also. Having said, why is everybody called Modi? All Modis are chores. Then he says, if you go looking, you will find more Modis are chores. He compounds his defamatory statement.
Yes.
No doubt the contemner should have been far more careful. The matter was compounded by filing a 20-page affidavit with a large number of documents annexed rather than simply accepting the mistake and giving an unconditional apology. Better wisdom dawned on the council only during the course of argument. Therefore, thereafter, when a subsequent affidavit dated 8th May was filed, we do believe that persons holding such important persons in the political... Well, now this is the Supreme Court in Rahul saying so. In the political spectrum...
Had the document come up before that speech, maybe better counsel would have prevailed upon him.
That's...
This is one very.
There I
don't interrupt. Your Lordship, because my learned friend is also continuing that mistake. Rafale order is dated 14/11/19.
I know.
The judgment, the speech at Kolar is 13/4/19. You can't take into account a subsequent.
So that's what we are telling him, that had this judgment come up earlier, maybe your client would have been more cautious.
But, my lord, but. I am fully aware that...
Wait, that's a
He did not interrupt you.
I'm sorry, my apology.
Not once.
My apology.
But,
I should not.
whereas the order is dated 14th November, the first speech attributing statements to the Supreme Court was on 10th. The second speech abusing the Modi community was on 13th April. And why am I citing this today? Is because this was taken into consideration at the time of sentence. Although it may have come later on, it is relevant at the time of sentence to take this order in, and the trial court has heavily relied upon this.
Yes.
The matter, and 31, and my learned friend wants me to read 32, so I'll just finish this. This is a short order. The matter was compounded by filing a 20-page affidavit with a large number of documents annexed. Rather than simply accepting the mistake and giving an unconditional apology, better wisdom dawned on the council only during the course of arguments thereafter, when a subsequent affidavit dated 8th May was filed. We do believe that persons holding such important positions in the political spectrum must be more careful. And I would add over here that even careful against members of the public.
And particularly when it comes to the highest functionary of the country.
And the highest functionary of the country, and also not them, a large class of people. You call them all chores. Just because of your malice towards the Prime Minister.
That you already argued that it's homogeneous class.
As to what should his campaign, what should be his campaign line, is for a political person to consider. However, this court, or for that matter, no court should be dragged into this political discourse, valid or invalid, while attributing aspects of the court which had never been held by the court. Certainly, Mr. Gandhi needs to be more careful in future. However, in view of the subsequent affidavit, better sense having prevailed, we would not like to continue these proceedings further and thus close the contempt proceedings with a word of caution for the contemner to be more careful in future. Now, my lord, an apology doesn't, it's well held by two judges of the Supreme Court that an apology does not eradicate the contempt or the conviction for it. It's an admission of guilt.
Yes. What is the next?
That was the last point. That's the last. Unless there's something else, your lordship.
No.
But the question which fell from my lordship about the constituency not having a member. Well, the constituency will elect a new member. It has to do it in September. Elections will be held. The time period being such. It's actually the right of a constituency.
It's a horoscopic predicament of
6 months time.
6 months time.
Constituency will elect a new member. It's actually the right of a constituency to elect somebody
who deserves
not a convict.
Not a person like this.
Not a person who had made rash statements on 2 occasions and were not broken the law. And now, and the law doesn't show any contriteness, at least in this case.
What weight with giving the maximum sentence? Because we were reading the judgment of the trial court.
Yes.
And then we went on to Rahul judgment. But they come back
Yes.
456.
Paragraph 4.
But what weight is that this Supreme Court judgment?
That's one. So he summarizes it in paragraph 4. I'll just read it and conclude.
Para 4, half of it you have already read.
Yes,
So
I read up to there is no change in his conduct.
Yeah. You read it from the last line, because by virtue of the member of parliament.
That the accused himself is a member of parliament and by virtue of the same to address the people is a very serious matter. Because by virtue of the member of parliament, when he addresses the people, it affects people extensively due to the same offence is more serious. If light punishment is imposed to the accused, the same will leave false message to people and the objectives of the law of defamation will not be achieved.